Welcome to our second lecture covering the Family and Medical Leave Act. Let's see where we are. We have covered the categories of employers who need to comply with FMLA. We've talked about which employees are eligible for FMLA, and we talked about the qualifying reasons. I think about these as being the EER, the employer, employee, and reason. We need to have all three of these resolved before we can reach a conclusion about whether a particular employee can have FMLA or not. In this presentation, we'll talk about the amount of leave that an employee is eligible for and the employer's rights and responsibilities under the FMLA. So let's advance to that part of the presentation. We're going to talk about how FMLA leave works. So the first thing to keep in mind is when we're not talking about the military scenario, each eligible employee is entitled to up to 12 work weeks a year, and the employee's work week is going to be the basis. So if you're an employee who works 40 hours a week, then it's going to be 40 times 12, I'm sorry, not a plus sign, but a times sign. And so that particular employee is going to be eligible for 480 hours. But you might have an employee who only works 30 hours a week, and so then you'd be looking at 360 hours and so forth. So we have to consider the particular schedule of the employee to make a determination about how many hours the employee is eligible. While the statute talks in terms of work weeks, we'll see that actually many times it plays out not being full weeks. And so it's usually a good idea to break it down into hours pretty early on so that you can figure out exactly when this employee's entitlement is complete. And so here we go into this category. Employees are oftentimes eligible for intermittent or reduced schedule leave. Imagine, for example, that I happen to have cancer and that I need chemotherapy or radiation therapy at certain times. And maybe I received the treatment on Wednesday afternoon. So I need to leave work, we'll say at 1 p.m. to get to the hospital to receive the treatment. And once I have the treatment on Wednesday, I'm probably going to be too ill on Thursday and Friday to come to work. So I'm going to miss half of Wednesday, Thursday, and Friday. But I'll probably be okay by Monday to come back to work. And let's assume I have a Monday through Friday schedule. Let's say I have this chemo treatment every other week. And so every other week I'll miss 2.5 days. Well, that would be an intermittent or reduced schedule leave. And you can see how thinking about it in terms of weeks doesn't really make sense. An employer can't require that I take more time off than I need to under FMLA. And so that can be the way that it works out. Another way that it can work out is would be kind of a scheduled situation. I mean, obviously a person knows when they're going to receive their chemo or radiation therapy. They may not know how long it's going to take for them to be well enough to return to work. That might be variable, but at least they know the starting time. But if I happen to have migraines, I don't know when I'm going to get a migraine, and I may not know how long it's going to last. I may not have any notice. It may just descend upon me, and I'm kind of in that particular predicament at that time. There may be other conditions that just come upon somebody like that, and so at that time the person needs to take the leave. So it can be unpredictable. That presents special challenges to employers. Let's say that I happen to have a receptionist who mans the front desk. She is not a highly compensated employee, so she doesn't qualify as a key employee, and she suffers from, we'll say, migraines. And so when she has a migraine, we don't get more than just a few minutes notice, and she has to be excused from work. Well, who's going to cover the front desk? I can't get a temporary person. Maybe the office is busy and all of the secretaries and office staff are otherwise occupied, and so you can see how it can present special challenges. Nevertheless, the employer isn't excused. The fact that it's awkward or inconvenient isn't a basis for the employer to deny the leave or not to respond appropriately by granting the FMLA leave if the circumstances meet that requirement. Now, one difference with leave in terms of intermittent or not is when there is child care, when you're taking time off for bonding. Usually, leave can be taken intermittently or with a reduced schedule based upon the medical circumstances. But of course, with child care, there really is no medical circumstance in play. And so an employer can require that it be one continuous block. So let's say you have an employee who wants to take off 10 weeks. And then, or let's say they want to take 6 weeks off, then come back to work for a month, and then take 6 more weeks off. Well, the employer doesn't have to agree to that arrangement. The employer can say, well, you have to take your 12 weeks or however many weeks you want in one block. That can be a policy that the employer has. But certainly the employer might say, gosh, we could insist upon that, but actually we would agree to you having some kind of intermittent leave. For example, the new parent might want to ease the child into daycare, or maybe he or she is having a family member do some of the care, and so he or she can work for some parts of the time. And so the employee might want, say, to take 20 hours of FMLA each week, maybe for a total of 24 weeks. And assuming that the employer agrees to that, then that is permitted. But if the employer doesn't want to agree, then the employer doesn't have to submit to that. That's not a requirement of the statute. We've already discussed the intermittent situation. And again, this is going to turn on what type of event it's going to be. Intermittent leave probably wouldn't make sense if it's bronchitis or if it's pneumonia, but intermittent leave could make sense if it's a chronic condition or a recurring condition. When the employer is calculating how much leave to count as having been taken by the employer has to use the smallest increment that it uses for taking care of time. So most employers look at 6-minute increments. Some employers look at time on the minute basis. So if you do time in the 6-minute increment, then that's how you have to treat FMLA. So let's say you happen to have an employee who wants to leave work an hour early every Thursday so that she can go to her physical therapy session. The employer, and let's say she ordinarily works until 5, but she leaves at 4:10. Well, then she should only be credited with 50 minutes of leave. If the employer does it in 6-minute increments, then probably she can't be credited with more than 54 minutes of leave. It should very closely match the actual amount of leave that's been taken. There is, that 12-month clock that we have to consider when we look at the FMLA entitlement. And there's 3 different ways that the employer can use to make the calculation. The employer gets to pick whichever method he or it wants to use, but the employer has to pick the method before the incident arises. And in fact, the method that the employer picks should be in the employee handbook if the employer happens to use an employee handbook. One method, and this is the easiest one for the employer to use, is the calendar year method. So everybody gets 12 weeks of FMLA kind of deposited into their account on January 1st. Another method is to use some kind of fixed period of time for example, it might, let's say the business has a fiscal year that's different than the calendar year. Maybe the fiscal year starts on March 1. Well, then that would be the start of that calendar. So this is the same approach as we see with the January 1 date. It's just that whatever the date is will depend upon that when the fixed calendar starts. These two have the benefit of being easy to explain and easy to calculate. But most employers choose the third approach, which is a rolling 12-month calendar. And what you do is you look back from the date that the employee is taking off back 365 days. And we see how many of the FMLA days the employer has taken at that point. And each day as you go forward, you're going to drop one day from the past. So as you go one day forward, you drop one day. And so if this period of time a year ago had been a time where the employee was taking FMLA, then every day you go forward, the employer is gaining back one day of FMLA, potentially. Of course, if a year ago the employee hadn't been using FMLA, then as we go forward one day, we're not going to be adding any more days. This is the most popular option, even though it's the most challenging to explain, and it does present some logistical problems in terms of calculating. But its real benefit is that it permits the employer to have to worry about granting, or not to have to worry about granting an excessive amount of FMLA. Let me give you an example. Let's say that I give birth to my child on October 7th, and I therefore take 12 weeks. And so I end up exhausting, I don't know exactly the date, but I end up exhausting my 12 weeks at around December 31st. And right when I'm about ready to return, I fall and break my leg, unfortunately. Well, if we're using this calendar year setup, then I am going to have 12 more weeks available for the situation. And so I can actually have a total of potentially 24 weeks back to back if it works out just this way. It could even be for the same condition. In my example, I had two different conditions, but let's just imagine for a second that I've been hale and hearty all the way till October. We'll say this one starts October 9th. I've been hale and hearty until October 9th, but then I need to have some pretty significant treatment. Maybe I've got a severe advanced type of cancer or something, and I'm going to need to have maybe a bone marrow transplant or some other very invasive procedure that's going to make me unable to return to work for quite some time. Well, I'd be able to take my 12 weeks under this program, the 12 weeks that I haven't used yet from January 1 to October 9th. And then once January 1 comes again, I will have used up this entitlement, but I will be given another 12 weeks at that time. So you can see in that scenario, an employee could get virtually back-to-back, assuming that the first incidence is late in the year, could get up to 24 weeks. And so that's the concern that the employer has. With the rolling system, you're always going to, once you use up if you have a continuous period of 12 weeks, then you're not going to be able to have another FMLA event for 9 more months until you start having the days roll off. So these are the three methods, and again, the employer can pick whichever one the employer wishes. It's the employer's choice, not the employee's choice. But this one is an especially popular one, and very likely to be the one that your employer will pick. Okay, this is a source of great confusion, perhaps more than any other topic. This one is confusing to both employees and to companies, and so there's lots of mistakes in this area. I'm going to explain to you what the law is, and I'm going to explain to you the misconceptions that's very, very common in this area. So if we think about it, an employee, here we go, an employee we might look upon it as having kind of two sources of leave. One is the PTO or sick pay or whatever the particular employer has. So maybe this is vacation pay, sick pay, whatever the terms are. So he has an allotment, maybe holiday pay in here. He or she has an allotment of paid leave available to him or her. They may have a variety of categories. I mean, obviously holiday pay isn't the same as vacation pay, which isn't the same as sick pay. But they all share the characteristic of it's time that the employee is off work and that he or she is being compensated. So this is one bucket that's available to the employee. And then the other bucket is FMLA. And we usually think about FMLA as being unpaid. And that's not a wrong way of thinking about it, because under the statute it is unpaid. And the reality is that some employees don't really have this first bucket, that the employee doesn't have any benefits through the place of employment. This isn't that uncommon with smaller employers. And so it may be that the only leave entitlement that this employee has is FMLA. If that's the case, then yes, FMLA will be unpaid. But if the employee has some paid leave, the next question to ask is, does the employee have any of this leave available right now? I mean, it could be that the employee has already used it up for some other purpose. And so at this particular moment in time, there is no paid leave available. But most of the time, the employee is going to have some of this time. And so what the employee can do is coordinate these two. So let's say on a particular day, let's say the day that Bob is in a bad car accident, he happens to have 4 days of vacation and 7 days of sick pay in his buckets. He is going to need 10 weeks off to recover from his very significant injuries. He works a 40-hour week. So he works, we'll say 5 days a week. And so we're talking about 50 days that he's going to be off. He obviously wants to be paid for as many of them as he can. So his first 11 of these 50 days, so the first 39 of the days will be paid. Some of it will be sick pay, some of it will be vacation pay. FMLA will be running concurrently with these. FMLA will start on the first day. So the first day he'll have a day of sick pay and also a day of FMLA that he's claiming. The second day will be the second day of sick pay and the second day of FMLA. And then the third day of sick pay, third day, fourth day, sick pay, fourth day of FMLA, fifth day of sick pay, fifth day of FMLA, sixth day of sick pay, sixth day of FMLA, seventh day of sick pay, seventh day of FMLA, first day of vacation pay, eighth day of FMLA, second day of vacation pay, ninth day of FMLA, third day of vacation pay, 10th day of FMLA, fourth day of vacation pay, 11th day of FMLA. If Bob has not become eligible for any more sick pay or vacation pay in the interim time, his 12th day of absence is just going to be the 12th day of FMLA, and he will continue to have FMLA up until the 50th day. If during those 50 days he becomes eligible for more sick pay or vacation pay, or perhaps holiday pay or something like that, then on that day he will use a day of FMLA and then a day of the paid leave. So the FMLA portion is always unpaid, but it can be coordinated with a paid benefit. Now the law says that either the employee or the employer can insist upon this coordination. And really it's a best practice for the employer to insist upon coordinating these two leaves. And so it's in the employee's best interest, it's in the employer's best interest to do this. So it's kind of a no-brainer. Have PTO or the vacation or sick pay or the holiday pay in the very first days of the FMLA leave. Let me explain, though, what the common misunderstanding is. People think that because FMLA is unpaid, that the employee, first of all, takes all of the paid leave and then the clock for FMLA starts. So with this common misunderstanding, what would have happened with Bob is that he would first take his 7 days of sick pay, then his 4 days of vacation pay, and then the employer would start the clock ticking on his FMLA entitlement. Well, with that method, that Bob would only use up 39 of his FMLA days before he returned to work, when in fact under the law he should have used 50 of those days. And so that is an incorrect understanding of the statute. Now, because they are supposed to run concurrently. Now, one of the reasons why employers get confused about this is that it has to do with the system coding. Most HR systems don't permit more than one code for a particular day. You can't code a day as sick pay and vacation day, for example. That wouldn't make any sense. You can only be paid one time for a day. And so similarly, systems are set up so you can't have sick pay on the same day you have FMLA. And so the system is coordinated so that you have one or the other, which means that the days aren't counted correctly. Now you might think, well, why don't we just make every sick day an FMLA day? Well, that doesn't make sense either, because the employee may not be FMLA eligible. Maybe he hasn't been with the employer long enough, or maybe the sickness isn't serious enough. Maybe he was only sick for one day, for example. So there will be plenty of times where the employee uses sick pay that are not FMLA eligible events. There will even be times where the employer, the employee doesn't have any sick pay and is just going to use FMLA on his own. Let me just address the issue of a situation in which the employee wants to save up his vacation. Maybe he's got an exciting trip planned somewhere. So he wants to use his sick pay perhaps, but he wants to save these 4 days of vacation. Can he do so? In other words, take after the 7 days of sick pay, take the remaining 43 days as unpaid so he can still take his vacation later on. Well, that can be an agreement that the employer and the employee reach, but the employer can insist that he take all of his paid benefits. The employee doesn't have an option if that's what the employer insists upon. And similarly, the employee can insist upon being able to use all the paid leave if the employee wants to. In addition to the paid leave options, workers' compensation leave runs concurrently with the FMLA entitlement. As with any kind of Americans with Disability Act leave, that would run with the entitlement. Now, both workers' compensation and disability leave might extend beyond FMLA. That can easily happen. Usually sick pay and vacation pay won't run that late, but it's possible that an employer had generous plans and they could run beyond the FMLA entitlement too. So hopefully that resolves that question. If you have questions about how to coordinate those two, please do reach out to me. I want to make sure you have an understanding on that, because this is a really common source of concern. You as an HR professional or a paralegal in this particular industry will likely be spending a fair amount of your time explaining to folks or resolving some miscommunications or misunderstandings that employees have. And it's not just employees, it may be your supervisors as well. So we've talked about the issue of the amount of leave that employees are entitled to. And by the way, when you talk about amount of leave here, we're not including the military situation. We'll talk about that in more detail here. So we're talking about the medical and family aspects, not the military aspects. Now let's talk about the employer rights and responsibilities, because there are several. And this is an area that can get confusing pretty fast. So the first thing I'm going to say is that you really have to get into the weeds on this. If it's your responsibility to make sure your employer is in compliance in this area, you need to kind of unpack the rules and make sure that you're dotting the I's and crossing the T's, that you have these already kind of set up as a process so that you can act on them quickly, because these events are going to be a pretty routine part of the workplace. As we talked before, pretty routine illnesses are going to be FMLA eligible events. And because the response time on some of these is very, very short, you can't wait until you have the employee with bronchitis to suddenly think, oh my gosh, we have to have a procedure in place. If you wait until that point, you've probably waited too long. You need to have procedures in place, and they can't simply be restricted to what the HR department's going to do, because the line managers and the supervisors also need to be aware that the time is of the essence in these areas. And once they hear about an FMLA possible event, they need to communicate promptly to somebody in HR so that the right forms can be sent out, so the right questions can be asked. So let's talk about these in more detail. One of the things that the employer has to do is provide notice to the employee of the employer's plan to count the absence as an FMLA event. And I'll show you an example of how you might go about doing that in a few minutes. Another thing that the employer needs to do is to maintain group health insurance. Let's pause here. This is assuming that this employer has group health insurance. Not all employers do, but assuming that the employer does have this, the employer is required to maintain this FMLA person on the group health insurance at the active rates while the employee is absent. Sorry, I should have been absent. Now, of course, if the employee isn't either eligible for the health insurance or has elected not to be in it, the employer doesn't have to make it available to the employee. But if the employee is participating, then this is not an event that is going to kick the employee out of the benefit. And keep in mind that with these intermittent type situations, especially employers who don't provide health insurance for part-time folks, what can happen is that, yes, you're maintaining the benefit, but now the hours that this particular employee is working is falling below whatever that threshold is. Well, they can't lose eligibility while they're on FMLA. So any requirements that they work a certain number of hours for a certain period of time has to be suspended while the FMLA event's going on. And again, if the employee is on some kind of an intermittent schedule, in theory and in practice, it can actually extend forever. An employee who maybe takes off, half a day on Thursdays or something, that can be every, day, and they will never use up their FMLA entitlement perhaps. And then finally, at least finally on this list, is that the employer has to reinstate the employee to essentially the same job that he or she had before the leave began. Now, there's a little bit of wiggle room here, but not much. The best course of action is going to be to reinstate the employee into exactly the same position, into the same unit, at the same shift, doing the same jobs. There could be a little bit of flexibility. For example, if I'm a secretary and I work in building A from 8 to 5, I can probably be moved to be another person's secretary in the same building, working 8 to 5, assuming that the job grade is the same and things along those lines. So there's a little bit of flexibility, but for the most part, usually you're going to move that person back to the same desk that they were in before. Okay, so let's talk about the general notice. Employers must inform employees of their rights under FMLA by putting up a poster, and also by putting a notice in the handbook if the employer actually uses a handbook. We've talked about posters before. You can get one of the all-in-one posters that, talks about Americans with Disabilities Act, Title VII, Age Discrimination Employment Act, the Polygraph Protection Act, the NLRA poster, and this, and there's probably some others in that too. And so that kind of makes a nice one-stop shopping type situation, but there's no requirement to buy a one poster fits all. You can certainly have each one of these posters being separate, and in most cases you can go to the website of the particular governmental agency and print it up directly from their website. So you do need to post this. The best practice is to post it in two places. One place where applicants would be applying, another place where employees are routinely going to be present. Examples of that could be around the time clock, or in the break room, or if you happen to have a locker room where that is. Or if there's a particular hall that all employees are going to be going down to and from work, that can make sense also as a place to put the posters. If you do not have the posters up, then there is the potential for fines, and they can be a daily fine. So it's important to make sure your posters are posted. I've seen incidents in which a particular department might have taken down the posters because they were putting up maybe holiday decorations, or they were doing some painting of the walls, and somebody forgot to put them up, or somebody didn't understand they were important they put up. And so there might have been a pretty significant period of time when there's no posters. That's not good. It's a good practice to keep them up. You might need to move them for if you're painting the walls or something like that. That's okay, but you do want to make sure that they are maintained and kept available for employees. So let's say that you are trying to communicate that, or that there's reason for you to think that a particular event may be FMLA. You have the duty within 5 business days of the leave request to inform the employee of his or her eligibility. And a common form to use for this is WH-381. Many times employers will use this as a starting point and then customize it to some extent. You usually, as an employer, you don't really want it to look like it's a government form. So let me just pull up the, here we go. This is the governmental form, but again, it does not follow that you necessarily want to keep the U.S. Department of Labor and the Wage and Hour Administration designation here. But this is a neat form to use. I recommend it. You can see that it provides all the statutory information. Now keep in mind, you've got to send this out to the employee within 5 business days of when somebody in your facility in a management position or supervisory position knows about it. So it might take a day or two to find its way to HR, and then HR is going to have to complete this. And you'll see that it really does require some pretty in-depth information about how the calculations might be made and all that good stuff. So you can't turn this around necessarily on a dime. But this is a smart form to look at for ideas about how to design one for your organization. We'll go to the next one. Next slide here. So this is, again, this is an example of the WH-381 of the notice that you can give to employees. Because of the tight turnaround time, 5 business days, this is a pretty common opportunity that employers do miss. They either don't send out the notice at all, or they send out one in a tardy format, and that is a violation, and it potentially could be prejudicial to the employee because the employee doesn't know whether his leave is approved or not. And so oftentimes the government may say, well, the clock didn't start ticking on day 1 of this employee's absence because you didn't tell him that it was going to count as FMLA. And so you might find instead of having to award this employee 12 weeks of leave, you end up having to award them, additional weeks beyond the 12 because you were delinquent in getting the notice to the employee. Let's look at the other form that you may be interested in doing. It's WH-382, and this is the designation notice. This is when you've decided that it has been approved. This is when we just had the pending request, and we're confirming that this person is eligible, and now we're confirming that the leave request has been approved. And again, this is a form you might want to use probably without the U.S. government notations on it. When you provide the notice of designation, you need to explain what amount of leave is going to count against the entitlement. If you don't know the amount of leave at that time, then the employer must inform the employee of the amount of leave designated upon the employee's request. Retroactive designation is very much discouraged, but it can be permitted in times where it doesn't harm the employee, that the employee is in a disadvantage because of that. But if you're going to say, oh, the employee has used up all of the FMLA because of this time in the past, the employee might say, well, if I had known you were going to count that absence from, 3 weeks ago as part of my FMLA, or more than 3 weeks ago, say 12 weeks ago, if I was going to count that, I would have come back to work earlier. And you can see how that could be causing harm to the employee if you were to make that designation. So the question is going to be, did the delay in the designation harm the employee? Again, if the employee is eligible and a participant in the health care benefit that the employer offers, then the employee's health insurance needs to be maintained, but not at the COBRA rates. You may recall that the COBRA rates are 102% of the premiums, but under FMLA, the employee is just going to pay his regular amount. Now, that's not always easy, because keep in mind, most of FMLA is going to be unpaid. I mean, the vacation, the sick pay, and the other benefits are probably going to run out long before the end of the 12 weeks. And so we have an employee who usually isn't going to be eligible for any kind of benefits such as unemployment. So it's difficult under those circumstances to make premium payments because you're not having any income. But if the employee is able to do so, then the employee certainly can maintain the benefit. Sometimes the employee, though, is going to choose not to, just not enough money to do everything under those circumstances. So when the employee returns, the employer has to immediately reinstate the health insurance at that time. The employer can't require an additional delay in establishing eligibility. So that does present some administrative issues to get that ironed out and that process to happen smoothly. Let's talk about that issue of reinstatement. So when the employee returns, he or she needs to be put into a same or equivalent job with equivalent pay, equivalent benefits, and equivalent terms and conditions. Now, obviously, the pay can be higher, the benefits can be better. No one's going to complain about that. But even a promotion could, so you might say, well, that's a better job. Well, maybe it's not better to this particular employee. Maybe it's a promotion, but the job is going to be more stressful or might involve more overtime hours or something like that. So if you're going to reinstate the person to a position other than something very, very close to what he or she had previously, it's a good idea to talk with the person, confirm that they are okay with that, maybe even get them to initial that they agree with this plan, or maybe even give them the option. Hey, Bob, you can go back to your old position, or we have this other position. Which one do you pick? And then once you have Bob's stated preference, you can proceed from that standpoint. Of course, you always have the option of just giving Bob the return to his old position. Okay, let's talk about that key employee. We talked briefly about that earlier, but I want to refresh on this one. Key employees must be salaried employees who are among the top 10% of the firm's employees in terms of compensation. They also have to have another qualification. The employer has to be able to advance the argument that to bring this person back after their FMLA leave would cause substantial and grievous economic injury to the employer's operations. For example, let's say that this is a very key person. Maybe it's the CEO of the company. And if they're going to need to be off for 12 weeks and you can't hire a replacement during those 12 weeks, there's no captain at the kind of guiding the organization. And so that's a very precarious situation. And so the company might say, we've got to find a replacement. We can't just sit on this for 12 weeks. And so unfortunately, you, CEO, are a key employee, and we're not going to be able to guarantee that you're going to be reinstated. For a CEO, you might be able to make that argument. But don't work under the assumption that all top 10% of employees in terms of compensation are going to fit into this category. You need both. You need the top 10%. Well, first of all, you need that the person be salaried. So the first requirement is they be salaried. Another requirement is they be in the top 10%. And then the third, which is by far the most difficult, is it's going to cause substantial and grievous economic injury. Now, with key employees, you can't deny them the FMLA. they are entitled to their 12 weeks. They are entitled to their 12 weeks, and they are entitled to keep the active rates on their health insurance. The thing they're not entitled to is reinstatement. Now, I will tell you that while this key employee designation is available to employers, most employers do not take advantage of it. Reality is, if you're looking for a new CEO, it's probably going to take you more than 12 weeks to find him. And so in most cases, for those really important people, you oftentimes want them back more than you want to be in a position where you're having to replace them. Again, proving this substantial and grievous economic injuries, pretty challenging. And keep in mind, again, these key employees are key to your organization. To kind of cut them loose in this way, not too many people are going to be too happy under those circumstances. So it's an option, and it's certainly something employers can consider, but it's not routinely done by most employers. Okay, let's consider prohibited employment actions. We've talked about the risk of retaliation claims under Title VII, under the Americans with Disabilities Act, and under the Age Discrimination and Employment Act. Retaliation absolutely happens under those statutes, but I would say probably the greatest risk of a retaliation claim is going to be under the FMLA. It's relatively rare that people aren't given their health insurance or they're not given reinstatement after an FMLA designation. Where we see most of the FMLA violations is the failure to grant the leave and then disciplinary action based upon the absence. So let's say I happen to have migraines. I happen to have that diagnosis. I miss 3 or 4 days a month. Not so much that if FMLA had been designated for me that I would have used up my FMLA entitlement. Well, my employer treats each one of those absences as an occurrence under the attendance program, and maybe my employer has a no-fault attendance program. Well, the employer concludes, Groover, you've just had too many absences. We're going to cut you loose. We're going to terminate you at this point. Well, that would be discrimination or retaliation against an employee for having exercised my FMLA rights. In this case, the way that I exercised those rights was by taking time off to address my health issue. I don't have to have talked about FMLA. I may not even be aware of the fact that the FMLA applies. But you can see under those circumstances, no-fault attendance policies can be very, very dangerous with FMLA in play. But there can be other ways that we see an FMLA retaliation claim. Obviously, the traditional way where somebody is denied FMLA and then they complain and then they're terminated for that. Or perhaps they stand up for somebody else in the workplace who was denied FMLA or was denied a leave of some type, even without the words FMLA being used. So all the traditional ways you can have a retaliation claim also exists in the FMLA world. The employer has to maintain records about this. It can become quite involved. When did FMLA begin? Imagine if it's an intermittent situation. You're going to have to code the hours a particular way so that you can keep track of which hours are FMLA and which hours might be otherwise. You have to keep track of the sick pay and the vacation pay. You have to maintain records of when notices were sent, what was contained in those notices. You have to keep track of the insurance side of things. So there's lots of different pieces of paper and lots of different information that you have to think through. How are you going to document this? How are you going to keep records of it? When a salaried employee takes FMLA, that isn't something that should be used to jeopardize his or her exempt status. We talked in the FLSA section, the Fair Labor Standards Act section, about how typically absences due to illnesses aren't going to result in deductions of pay. You can't have, especially in the case of FMLA, you can't have those I mean, you can have the deductions in pay with FMLA, but you can't have the jeopardizing of the exempt status. So for the most part, FMLA is not going to affect the exempt status of a salaried employee under the FLSA. We've already talked about this. Probably the greatest risk for employers is the act of disciplining employees who have absenteeism issues, which may be attributable to an FMLA event that was not identified appropriately. So this really requires being very careful about terminating people for absenteeism reasons. Now, there's no problem firing people for absenteeism when they are absent because of flat tires or undependable transportation or sleeping in or things like that. But when you start seeing health reasons, either the employee's own health reason or a family member's health reason, that's when you have to kind of separate those things. And if you are firing somebody, let's say they've had 5 occurrences, and according to your disciplinary process, on the 5th occurrence, that's when termination happens. It doesn't have to be that all 5 of them are FMLA. Maybe only one of them was FMLA. But if you take that one out, then that particular employee only has 4 occurrences. So he or she shouldn't be fired. Now you might say, well, yeah, but if they've already had 4, they probably would have had a 5th. Well, that's not what the employee's going to say when he sues the employee. He's going to say, I wouldn't have had any more. You never would have fired me. But you did fire me because you inappropriately counted that one FMLA absence as one that was subject to discipline when in fact it wasn't. And so you retaliated against me for exercising my rights under the FMLA. So how do you address this as an employer? How do you keep good attendance? How do you handle this? Well, one strategy, it's not perfect, but it is something that is worthy of consideration, is to be aggressive during the first year of employment. During the first year of employment, the employee isn't going to be FMLA eligible. But you still do have issues. I mean, you can't retaliate against workers who take off workers' compensation. You still have to be aware of the Americans with Disabilities Act limitations. So there are some constraints. But for the most part, you're going to be able to address attendance issues on a no-fault basis during that first year of employment. And in many cases, there are warning signs about an employee who has attendance problems that are going to percolate up through the system during that first year. So that's one way of addressing these types of concerns. Another important strategy is, once the person has had their first year anniversary, is to make sure you have checks in place so that before he or she is dismissed or perhaps even suspended or something along those lines for attendance, that there's somebody who has a pretty sophisticated understanding of FMLA who does an audit of those absences. Hopefully there's an evaluation each time the employee is absent. But if you miss a few, it's not the end of the world, assuming that you catch it before you terminate the person. So having that last check before you pull the trigger and terminate the person can be a really smart strategy. If you discover, for example, that 1 or 2 of those absences really could have been FMLA, you're not going to be able to count it against this worker's entitlement because, of course, that concern about prejudice, but you will know that you're not going to count that absence, and so the person's attendance record becomes less problematic in terms of the discipline that's necessary. So this is something that does require a pretty careful attention. It used to be that firing someone for attendance was a pretty straightforward, pretty clean way of ending an employment relationship. After FMLA, it's one of the more dangerous ways of ending an employment relationship after that first year anniversary. So at this point, we have covered both the amount of leave that an eligible employee is entitled to under FMLA, and we've discussed the employer rights and responsibilities under the FMLA. We'll continue on in our next presentation to talk about employee rights and responsibilities, as well as the special elements of military family leave, and we'll even talk about the statute USERRA. I hope this information has been helpful for you. As always, if you have questions about the material, please don't hesitate to contact me. My email is cgroover@collin.edu. I would be delighted to talk in more detail about these topics with you. I thank you for your attention, and I hope that you have a wonderful day. Take care.